Now is the time for turning. The leaves are beginning to turn from green to red and orange. The birds are beginning to turn and are heading once more toward the south. The animals are beginning to turn to storing their food for the winter. For leaves, birds, and animals, turning comes instinctively, but for us, turning does not come so easily. It takes an act of will for us to make a turn. It means breaking with old habits. It means starting all over again, and this is always painful. It means saying, I'm sorry. It means recognizing that we have the ability to change. These things are hard to do. But unless we turn, we will be trapped forever in yesterday's ways. Spirit within, from callousness, help us to turn from callousness to sensitivity, from hostility to love, from pettiness to purpose, from envy to contentment, from carelessness to discipline, from fear to faith, and I might add, from comfort to courage. Turn us around, Spirit within, and bring us back. Revive our lives as at the beginning, and turn us toward each other. And so with that, we will begin a Sunday forum on the upcoming ballot initiatives, November 3rd. And we have to lead that discussion, Bill Isaeff. Bill is a former Deputy Attorney General for the state of Nevada and Deputy City Manager for the City of Sparks, City Attorney for the City of Reno. He is famous for being lead negotiator on the Area Water Agreement of 1996 that brought together the Paiute tribe at Pyramid Lake, the cities of Reno and Sparks, Department of the Interior, and other stakeholders, and is an acknowledged expert on water law. And since his retirement, he's been actively engaged in the history of Reno and Nevada, and he could tell you more about that some other time. You will see there a few of his many awards over the years on his wall behind him there. So Bill, the platform is yours.
Thank you, Kevin. Good morning, everyone. Thank you so much for having me back for this particular time when we go through the biennial state ballot questions. There are 5 questions on the ballot this year. You should all have received your mail-in ballots, which were mailed out to all Nevada voters this year by a decision of the legislature. And there, as I say, 5, although one of them is actually numbered number 6. There is no number 5 this year. There's something unusual about this particular set of 5 ballot questions. There are no organized campaigns either for or against any one of these ballot questions this time. I can't remember a time when that has happened before, that because you haven't seen any TV ads for, vote yes on one, vote no on one, or any mailers or newspaper ads or anything like that. A most unusual situation. Now, 4 of these questions have never been before the public before. And so you might expect that there would have been something organized, but there hasn't been. And then question number 6, which we'll get into later, has been before the public in 2018 for a prior vote. So with that kind of a little bit of an explanation, let me tell you how these got on the ballot. 4 of these questions came to you for your consideration through the process in our Nevada Constitution, which allows the Nevada legislature to propose amendments to our Constitution. In order to do so, 2 separate sessions of the legislature must approve the resolution proposing a constitutional amendment. And you will see on questions 1, 2, 3, and 4 that each of those have been proposed in the 2017 and 2019 Nevada legislative sessions, and they're now on the ballot in 2020. And that's that process. So When you do that, it takes about 4 years to amend the Constitution in Nevada using that process. The last question we'll talk about, question 6, is on the ballot today before you through what's called the initiative petition. In the early 20th century, there was the so-called progressive movement, which was looking to modernize government and spread democracy back to the people. And one of the ideas of that was to allow the people to propose their own legislative enactments or constitutional amendments. Nevada was one of the states to adopt that procedure. And so this particular matter is before you on question 6 through the initiative petition process. Petitions are circulated around the state, signed by voters saying, yes, I want to put this on the ballot. If enough signatures are gathered in time, then that appears on the ballot. And that's how question 6 comes before you on the ballot for this particular time. When it's done that way, there have to be 2 votes by the people. Just like there's 2 votes by the legislature to put it on the ballot, under the initiative process, the people have to vote twice. Question 6 was voted on already in 2018, and we'll talk about that when we get to that question. So that's how all of this gets before you every 2 years on your ballot. Let's turn our attention to question number 1. It's the biggest and longest, and although there's no organized opposition, I would say it's perhaps the only one that might be somewhat controversial. Shall the Nevada Constitution be amended to remove provisions governing the election and duties of the Board of Regents of the state university and require the legislature to provide by law for the university's governance, control, and management, reasonable protection of individual academic freedom at Nevada's public higher education institutions, and revise the administration of certain federal land grant proceeds dedicated for the benefit of certain departments of state government. Now, our Constitution since 1864 has provided for a Board of Regents to govern the university system. And of course, as we know now, it's not just one university like it became in the late 19th century. It's the whole system now of universities, colleges, Truckee Meadows community colleges, et cetera. So it's a very large organization now. This ballot measure would require, would do a couple of things. It would remove all references to the Board of Regents from the state constitution, and in turn give the legislature the authority to restructure the management of the state university system in the manner which the legislature thought best. Although none of the existing statutes relating to the university system would be automatically repealed by this amendment, it would nonetheless give the legislature the power to make changes to any existing statutes and enact new ones as they thought appropriate. The measure would also require the legislature to take reasonable protection of individual academic freedom for students, employees, and contractors under the Nevada education system. A yes vote would favor removing the provisions governing the Board of Regents from the Constitution. A no vote, of course, would do exactly the opposite. It would indicate retain those provisions in the Constitution. There's been for a very long time a tension between the University of Nevada, or pardon me, the university system, the Board of Regents, and the legislature for quite some time. That has come about because the university system now through the Board of Regents has a high degree of management control and authority over the system, and the legislature less so under our current structure. Now, the legislature, of course, still controls the budget of the university. They have to submit a budget. The legislature has to approve that budget. But how that money gets spent is almost entirely up to the Board of Regents to decide. The legislature would like, I think, more authority and control over those kinds of decisions at the university. There also was a kind of a brouhaha back in 2010-11 when the university was accused of not giving proper information, financial information to the legislature during that particular session. That I still think is rubbing some legislators raw down in Carson City. So you've got a situation where the university would definitely be changed if this were passed. One of the things that the proponents of this, or pardon me, of the opponents of this are worried about is we have an elected Board of Regents right now. There are 13 of them, and they are elected in different districts throughout the state. Opponents of this are very fearful that what the legislature intends to do is to take away our right to vote for the regents and either substitute an appointed board or perhaps a hybrid board. And there is some evidence to show that that is the intent of some legislators. In 2019, a bill was introduced in the legislature which passed the Senate, which reduced the number of regents from 13 to 9 and said 5 of them would be elected and 4 would be appointed by the governor. That bill, however, did not pass the legislature, so it is not law or law that would take effect if this amendment goes through. But the opponents cite that as a concern to them. Nevadans do tend to like voting for public officials. We certainly have lots of them on the ballot to vote for. On that academic freedom aspect of this, there are, of course, federal court decisions which define academic freedom now under the federal Constitution. And this would give the legislature the opportunity to go beyond the federal protections and perhaps extend more protections to educators, students, and others dealing in the university environment. The opponents, of course, say, we don't need that. We've got sufficient protection under federal constitutional court cases for this type of activity. So. That's, there's a financial thing of this that is so difficult to understand. I'm not even going to go into it too much. You may recall the University of Nevada is a moral land grant college, like many of them here in the West. And there were certain special provisions made for funding state colleges in the 1860s by the Morrill Act. And in fact, Morrill Hall is named for this very senator who helped pass this. And so that would just change the way some of those funds are handled and administered administratively. So the question is, before you, is do you think that it's time to change the governing system? Is there, and again, the opponents say, what's the change going to do? How is this change going to in any way improve, say, the academic performance of the university, which already has some fairly high ratings by certain institutions? What will it do for student fees and things like that? So even though there's no organized opposition, when you look at the arguments for and against this, they're pretty strong on both sides. There are strong advocates to make the change, strong advocates for not making the change. So that's basically what you're going to see in question number 1. And the system, they say, has been the same for 150 years. Why change it? And again, the opponents. The proponents of this matter say it's time that we bring the university system perhaps up into the 21st century, where more appropriate ways of dealing with the issues that arise in a university system can be handled by our elected representatives in the state legislature.
So with that, the audience has an opportunity to question and comment. I do have a question first, Bill. Was Senator Morrill, in fact, a Nevada U.S. Senator?
He was not. Don't hold me to this. I think he was from the Midwest, perhaps Iowa, but I'm not certain.
Interesting. So questions and comments.
Yeah, so questions are coming in, Bill. The first one was, what was the, how was the 2010-11 brouhaha that you described resolved?
Well, I'm not sure it ever was resolved, but the person who was involved in it resigned in 2017.
Do you believe that this means that the university system will become more political?
That is certainly one of the arguments of the opponents. The university system has for a long time, as I say, been in this tension with the legislature. They have even from time to time advanced the idea that they're the fourth branch of Nevada government. This idea has not set well, by the way, with other branches of the real true branches of Nevada government. And there has actually been a court case involving this very issue. And one of the concurring judges talked about, well, this system is set up so that the university does not become the political football of the legislature. So there has been this kind of tension. They have asserted this. There was a case in which the legislature wanted to pass a law that applied to all of the other state institutions. The university said, no, but it doesn't apply to us. Now, they lost that case because the Supreme Court said, as long as the law applies to every state institution, it can apply to the university. But the legislature right now cannot pass special laws that apply only to the university.
Which of the groups, the legislature or the Nevada System of Higher Education, would you consider more progressive?
That's kind of a tough call. I am not that familiar with the regents personally. And then the legislature, of course, is subject to wide swings because, as you know, one party sometimes gains control of both houses. Sometimes it's a split between the houses. So obviously, the legislature can be the more political body to deal with and more uncertainty as to which directions it might be wanting to go at any time.
So which of these, the legislature or the Board of Regents, knows the university situation better, financially or otherwise?
I would think probably the Board of Regents, because they have been in this role for, of course, 156 years. Many of them have served multiple terms. They're supposed to be dedicated, of course, to the advancement of the university and the educational system of the state of Nevada. So my personal view would be that probably the Board of Regents does, at least at the present time, have a better understanding of the university than perhaps the legislature. But that may also be because of the tensions that have existed in the past, that the legislature perhaps feels they do need to know more about that system and its operations.
You described a 2018 vote. What was the result of that vote?
There is no 2018 vote here. The 2018 vote is only on question 6. This one is before us for the very first and only time. Okay,
thank you.
Should we move on, Phil?
Yeah, I'm just going to ask one other question because there's a lot of questions coming in. And I think, where can folks learn more about the pros and cons of this, would you say?
Well, there is a story in the morning paper, and it'll also be on rgj.com about question 1. You could look there. John Ralston's Nevada Independent has some excellent reviews of each of the ballot questions on his website. As I say, the Nevada Independent, I think, .com or something like that. So those are some good sources of additional information if you'd like to do some more research this week before you make your decision.
Okay, thank you, Bill. We'll go ahead and move on.
Question 2. This is, again, one that has come to us through the legislative process, having been approved by the legislature in 2017 and 2019. Shall the Nevada Constitution be amended to remove an existing provision recognizing marriage is only between a male person and a female person, and require the state of Nevada and its political subdivisions to recognize marriages of and issue marriage licenses to couples regardless of gender, require all legally valid marriages to be treated equally under the law, and establish a right for religious organizations and clergy members to refuse to perform a marriage and provide that no person is entitled to make any claim against them for exercising that right. Those of us who have been here for some time will recall that in 2000 and 2002, a ballot initiative appeared there to put into our Constitution the definition of marriage being only between a man and a woman. And it was approved at both of those elections and became a part of our Constitution. In 2015, the United States Supreme Court ruled that under the federal Constitution's Equal Protection Clause, provisions like that, state laws and constitutional provisions like ours, were unconstitutional, could not be enforced. So since 2015, this has been unenforced and unenforceable here in Nevada. Question 2 would simply take that language out of our Constitution, and we would be following the federal constitutional directive. The opponents of that have said, well, that decision, Obergefell versus whoever, anyway, that decision was a 5-4 decision of the United States Supreme Court, and it could someday be overturned. And if it is overturned, then of course, if this provision stays in our Constitution, it will automatically be revitalized and will become the law of Nevada once again. And so we should not take it out at this time. And that's a kind of an interesting argument, because I would never have thought that up until just very recently, when with the death of Justice Ruth Bader Ginsburg and the nomination of Judge Bartlett, a person who is widely known to be anti-same-sex marriage. I guess the possibility exists that it could be overturned. I don't think, as a lawyer, I don't think it's going to be, because I think it would create just legal chaos. But you got to admit, the possibility is there. The votes could be there. So what we have here is simply taking that out of the Constitution. And I think most people would agree, opinion on same-sex marriages has greatly evolved since the early 2000s to a time now when I think there is widespread general acceptance of the concept that same-sex marriage is entirely appropriate and should be recognized in law. So that is where we are with respect to this particular question. Questions?
Yeah, Bill, we have one that's come in already. What would happen if this issue passed and the ruling was overturned at the federal level?
I think what would happen would be then every individual state, just like it was before the Supreme Court decision, would be able to make their own decision on this topic. And we would then probably once again have widely diverse laws in different states as to whether or not same-sex marriage would be appropriate at that time. The question I don't know the answer to is, what would you do with the tens of thousands, hundreds of thousands of people who have gotten married in the interim? And I just don't really know what the answer to that might be. The courts would have to deal with that, obviously. But we would have probably 50 different schemes on same-sex marriage, which is similar to what we had before the federal decision came down.
Okay, any other questions? You can go ahead and put them in the chat. So just to clarify, a yes vote would be a vote for marriage equality.
A yes vote will remove the current statutory or constitutional provision on same-sex marriage in Nevada from our Constitution, and we would be moving forward under the federal decision. A no vote would leave that provision in our Constitution, even though it is currently unenforceable.
Does the Constitution of Nevada currently contain a religious exemption?
I'm not sure that it does. I'm not positive on that. This does definitely make that a clear situation for clergy and religious organizations. And then of course we've got the issue, well, if you have that exemption for them, what about other people? And that question I don't think is fully resolved yet, but this would be a clear protection for clergy and religious organizations.
Okay, I think we're ready to move on.
Question number 3. Again, this one comes to you from the legislature, having passed a joint resolution in 2017 and 2019. Shall the Nevada Constitution be amended, 1, to require the State Board of Pardons Commissioners, whose members are the governor, the 7 justices of the Nevada Supreme Court, and the Nevada Attorney General, to meet at least quarterly, authorize each member of the board to submit matters for consideration by the board, and authorize the board to grant pardons and make other clemency decisions by a majority vote of its members without requiring the governor to be part of the majority of the board that votes in favor of such decisions. Now, this will do basically three things. It will require them to meet at least quarterly. Currently, state statute only says that they, quote, may meet at least twice a year. They have, in the 6 of the last 10 years, only met once, I understand. And then other times they've met 2 and 3 times a year. The proponents of this say that it would be more appropriate and would allow for better handling of these applications if they met somewhat more frequently. I have not, it says here, authorize each member of the board to submit matters for consideration by the board. In my research, I was not able to find anything that limited them from doing that now, but at least this would make that clear as a part of the Constitution, that any one of the 9 members of the Board of Pardoned Commissioners could submit a matter for consideration. So that just seems to just be perhaps putting in writing what the current practice is. But the big thing here is number 3. Authorize the board to grant pardons and other clemency decisions by a majority vote of its members without requiring the governor to be part of the majority of the board that votes in favor of such decisions. Nevada is the only state, I understand it, has this provision where the governor of the state therefore has a veto over any decision of the Board of Pardons Commissioners. Because if the governor does not vote in the majority, then no matter how many other pardons commissioners vote yes for a pardon or a clemency application, it's denied. And so this makes a major change. One of the opponents of this change indicate that many states don't even have a board or commission like this, and the governor is given the sole authority to make a decision like this. So it's not all that unusual that this unique power is of yes or no is given to the governor by him or herself. Twenty-one states, I mean, have an executive or administrative board like ours. 29 states have that one that I told you where the governor has the sole authority on his own. There's a fiscal impact to this. I didn't mention that in the others because the Legislative Counsel Bureau, which is required to analyze these ballot questions and attach a fiscal note if there's going to be a monetary consequence to its adoption, did not have fiscal notes on either of the other 2 saying that it was not possible to determine any kind of fiscal impact. This one, however, does have a fiscal note attached to it by the Department of Public Safety and the Division of Pardons, saying that they estimate it will cost approximately $240,000 per year to implement the provisions of this constitutional amendment if it is approved by the voters on November 3rd. Are there any questions?
Not so far. We'll give it a minute and see if folks have questions. Yes, first one came in from our frequent questioner. Are pardons and clemencies only granted after the board meets? I.e., if they meet once per year, these are only granted once a year? Do you know how many pardons and clemencies are considered in a year's time?
I do not know that latter number, but yes, the process operates only when the board meets. You have to make an application to the board. It gets investigated by the appropriate state agency and presented to the board for its consideration. There are also procedures whereby victims have to be notified, prosecuting authorities have to be notified, and in this hearing, they have an opportunity to come back before the board and make their case for why they believe the application should be denied. It's a fairly complicated legal procedure, and obviously it's not granted without serious consideration.
We have a question about the commissioners on the board, but it sounded like those were the governor, the Supreme Court justices, and the Attorney General. So they're elected positions. Okay.
They're all elected people who serve on the board. That is correct.
Thank you. What accounts for that significant financial impact? I have to say I was surprised by that as well.
Okay, let me look right here. We're at fiscal note. Because they would be meeting more often, at least quarterly, it cost approximately $4,250 for each meeting. To the extent that we're required to be, the board would incur additional expenses of $4,250 for each meeting. Let's see, the Division of Parole and Probation of the Department of Public Safety, which provides staff support to the board, has indicated that allowing any member of the board to submit matters for consideration in conjunction with the increase in the number of meetings that must be held will increase the workload of the division. As I mentioned, I could not find anything that would prohibit that now, but maybe I missed something. The division estimates it will require 2 additional staff members to provide support to the board with managing its caseload, resulting in an approximate increase of $175,000 per year. So I took the 175 and the 65,000, added that up and came up with 240,000 as the estimated cost per year to implement this. Now, that's what the agencies are saying. I'm not vouching for the numbers of the need for the staff.
And Bill, another question is this the first time this has gone up in front of the voters, and therefore we expect to see this back in 2022?
No, this is one that was already passed twice by the legislature in the process there that I explained earlier, so it only goes to the voters once. The initiative process, which is a petition signed by the people and the voters themselves to put something on the ballot, that's the one that has to come to the vote twice. So this will only be a one vote, up or down 2020.
Thank you. And another question, does a pardon mean that the individual gets back their voting rights?
A pardon does restore a great many of the rights that are taken away by a conviction. That is correct. And voting rights are one that I think have now been restored here in Nevada by law.
Thank you. So Bill, okay, are we talking felonies, or just any type of conviction?
I believe we're talking all types of convictions.
Okay.
I think we're ready to move on. For which the board has authority.
Okay.
Oh.
Don't know that number.
Yeah,
Not the wrong way. I would just add, by the way, Rachel makes the comment, this seems not to take into account the cost of incarceration of people who might be pardoned or receive cleansing.
It does not, in the fiscal note, make reference to that. And as you know, incarcerating a convict in the Nevada state prison system is very expensive.
Okay, Bill, I think we're ready to go on to the next initiative.
Question number 4. This is another one that comes to us by action of the Nevada State Legislature in 2017 and 2019. Shall the Nevada Constitution be amended by adding a new section guaranteeing specific voting rights to all qualified and registered voters in the state? This would amend our Constitution and put in a provision that would guarantee the constitutional right to voters of the following items. Receive and cast a ballot that is written in a format that allows for clear identification of the candidates and accurately records the voter's selection of candidates. Have questions concerning voting procedures answered and have an explanation of the procedures for voting posted conspicuously at the polling place. Vote without being intimidated, threatened, or coerced. Vote during any period of early voting or on election day if the voter has not yet voted, and if at the time that the polls close, the voter is waiting in line to vote at a polling place at which by law the voter is entitled to vote. Return a spoiled ballot and receive a replacement ballot. Request assistance in voting if needed. Receive a sample ballot that is accurate, informative, and delivered in a timely manner as provided by law. Receive instruction on the use of voting equipment during any period of early voting on election day. Have equal access to the election system without discrimination. Have a uniform statewide standard for counting and recounting all votes accurately as provided by law. and have complaints about elections and election contest resolved fairly, accurately, and efficiently as required by law. Now, we have here these important constitutional guarantees are similar to voting rights that already exist in Nevada law. We have, in fact, passed a law that provides the exact same 11 things that I just read to you as voter rights. But it's a statute, not a constitutional provision. And so, as you know, statutes can be changed much more easily than amending a constitution. And so I think the proponents are saying these rights are so important to voters, they should be enshrined in the Constitution so that any changes to them would only be made by subsequent decision of the voters themselves in having to change the Constitution. Voters will be assured, no matter how the political winds may blow, any attempts to diminish or otherwise interfere with voting rights or with election outcomes in Nevada will be much more difficult to accomplish with these constitutional protections in place. That's one of the arguments for passage of the amendment. And we have seen, particularly since the US Supreme Court took out or removed the protections that were afforded by the Voting Rights Act for certain states having to submit their election laws to the Department of Justice for review to make sure that they were not in fact discriminatory. We have seen in a number of states actions in the last 4 or 5 years to apparently make it more difficult for people to vote in some elections. And I think that's what the proponents of this are saying. This would help protect us against, because it would be a Nevada constitutional provision and not something that the legislature could change easily on its own or enact laws that would run counter to the protections set forth in this particular provision. Arguments against the passage. Nevada's voting system functions exceptionally well as it is, and basic voting rights are already enshrined in both the Constitution and the Nevada Constitution. There's a reason that voting rights in question 4 exist in statute and have not been added to the Nevada Constitution in the past. These voting rights, while vitally important, are not timeless in their structure or application, and the forms they take may change substantially as the ways in which we vote and conduct elections evolve. Further advances in technology will likely make several of the voting matters addressed by question 4, such as written ballots, polling places, and even in-person voting, obsolete. So while they think every voter should feel secure in his or her ability to vote, the opponents of this suggest in their arguments against passage that this is a solution in search of a problem. There is no fiscal note to this. The Secretary of State indicates no additional expenses likely to be incurred by her office should this amendment pass. I suppose in part because, as I said earlier, all 11 of these rights are already enshrined in Nevada state statute, but not in the Constitution. This would add that to the Constitution as further protection of those rights. Any questions?
None so far. We'll give it a minute, Bill.
Okay.
Nope, maybe they're anxious for the last one, Bill. So
Okay. Question number 6. This is the only question on the ballot that comes to us today through the initiative process. There was an initiative petition circulated in Nevada back in 2018. It was heavily supported by Tom Steyer. You may recall he ran for president for a brief period of time. He's a California billionaire. He does a lot of philanthropic work, et cetera, et cetera. He has taken a substantial interest in matters relating to climate change and energy provision, et cetera, et cetera. So he was one of the key people behind this initiative petition. It received almost double the number of signatures on the petition to qualify to go on the ballot in 2018. It went on the ballot. It received a vote in 2018 of almost 60% approval. But as we pointed out earlier, when ballot questions are initiated this way, it requires 2 different elections and approvals by the voters of Nevada. So that's why it's back before us today in 2020. Basically, the question here is, shall Article 4 of the Nevada Constitution be amended to require, beginning in calendar year 2022, that all providers of electric utility services who sell electricity to retail customers for consumption in Nevada generate or acquire incrementally larger percentages of electricity from renewable energy resources, so that by calendar year 2030, not less than 50% of the total amount of electricity sold by each provider to its retail customers in Nevada comes from renewable energy. Those of us here in the North know that we get our bill every month from NV Energy, the former Sierra Pacific Power Company. And this, of course, is directed right at them and at the provider in Las Vegas, whose name I don't remember at the moment. So we have here in this amendment a series of percentages. Right now, we are at 20% by state statute. That has to be renewable energy from NV Energy to us, their customers. This provides that in certain calendar years in the future, those percentages will increase. For instance, in 2022-23, it goes to 26%. For years 2024 through 2026, not less than 34%. For years 2027 through 2029, not less than 42%. And for calendar year 2030 and each calendar year thereafter, not less than 50% of the total amount of electricity sold by the provider in Nevada during the calendar year shall come from electricity generated from renewable energy resources. Now, as I mentioned to you, this was on the ballot in 2018, and it received a substantial number of yes votes. That may be why, because in 2018, there was a big campaign about this. There was a big campaign yes, and a smaller campaign no for the passage of question 6 in 2018. We saw lots of Tom Steyer ads on TV, blah, blah, blah. This year, nothing. And I think it's in part because people probably felt, since this received such a large majority in the 2018 election, it's probably going to pass again this year. Well, one of the interesting things I discovered was, after the 2018 election, where the public expressed pretty strong support for this idea of gradually increasing the amount of renewable energy resources to provide us electricity up all the way to not less than 50%, in 2019, the legislature actually did that. They passed NRS 704.7821, which mirrors all the language of the amendment that I just read to you. So that we actually now have this step-up provisions for renewable energy resources in state statute. Now, you won't find that by reading the ballot explanation, because, as you notice, there's no question 5. And the Secretary of State has said, well, question 6 was question 6 in 2018, means it has to be question 6 in 2020 as well. Okay, I can understand that, but the ballot explanation does not reflect the fact that the legislature took some action on its own in 2019. So the ballot explanation no longer is quite accurate. It only references the prior law when we were only 20% and coming up to 25. So I just want you to know that whether this passes or not, we've already got those provisions in state statute. But as I suggested earlier, I suspect this will receive approval of the voters once again, because it was popular in 2018, and I see no reason to think it's probably not going to be popular again. A yes vote.
I just want to add a quick comment on the 2019 legislature that I thought was very interesting, which is that they redefined what renewable meant to include nuclear power.
Thank you, Philip. I don't think I picked up on that. So here we get a constitutional provision. The opponents of this say this isn't something that should be in the Constitution. It should be in statute, because as things change in the future, technologies again change, improve, et cetera, the legislature, needs to be able to respond to that. Well, I don't see anything in this constitutional amendment, of course, that prohibits the legislature from continuing to increase the percentage. And in fact, you'll notice it says at least 50% by 2030. So the legislature could, I think, under this provision, should it be approved, increase that percentage to 60 or 75% if the facts justify doing so at some time in the future. The proponents also think that this, of course, will lead to cleaner air and healthier families by replacing dirty fossil fuels with clean energy. Question 6 would reduce emissions of toxic pollutants like sulfur dioxide to make our air less safe to breathe. There is a big movement, of course, of getting away from coal, notwithstanding President Trump and his efforts to push coal as a source of energy, moving more towards natural gas, and even away from natural gas. Natural gas produces pollutants that are harmful to the air as well, just not as much as coal burning, of course. So there's certainly a move in the direction towards solar, wind, hydro power, et cetera, where that's available. Not much of that here in Nevada, but except in the southern part of the state, et cetera. And pointing out that the cost of clean energy is getting cheaper than dirty energy. Electricity from new large-scale solar power plants in Nevada is already cheaper than electricity from a new power plant fueled with out-of-state gas. The cost of energy storage is also declining, making solar an even more attractive option. So let me just kind of look here quickly at what the opponents for this one had some kind of interesting things. It was real nativism here. Home means Nevada. Let Nevadans decide, not some San Francisco billionaire. Don't fall prey to some billionaire with a previous questionable motives. The most of these things that are actually here in the official Secretary of State's ballot explanation with the rebuttal arguments is going after California and or Mr. Steyer. But as I mentioned to you before, they also point out that, look, this is already a part of state law and we don't need to have it in the Constitution. So that's pretty much where we are here on our particular five ballot questions. They're not difficult, I think, to understand. I hope that each of you found something here that I have been able to enlighten you a little bit about how you want to make your informed decision on each one of these. We have an opportunity every 2 years to be legislators ourselves, to pass laws, pass constitutional amendments. It's just as important as when you vote for a person. Matter of fact, I would argue it's more important, particularly when we're talking about constitutional amendments, because when those things are approved and go into the Constitution, as I pointed out very earlier in my presentation, it's not easy to amend the state constitution. It takes at least 4 years from the beginning to end of that process. And so you want to be certain that you're making the right decision here when you do this. But so as I say, it's important to vote for the people because of course they're going to be the ones every day making the laws or enforcing the laws, et cetera. But these questions are just as important to you as a voter as the names on that ballot that you'll be casting your vote for probably in the next couple of weeks, maybe November the 3rd, whatever your choice is going to be. You know, thank you very much for giving me this opportunity. I love doing this talk every 2 years, and I look forward to perhaps doing it again in 2022. I want to wish all of you a very good day, and of course, stay safe.
Thank you, Bill. And what I'm going to do is actually go ahead and open it up for folks to talk to you or to ask questions verbally at this point, and we'll just leave it as an open forum, and I'm going to stop recording at this point.
Sounds
So
good.
Thank you so much, Bill.
Sounds good.